Well, I'm sorry for the ragged start. This is the League of Women Voters program in partnership with the Detroit Public Library. We've been doing this since actually September of 2020. Hard as that is to believe. This is a partnership between the two organizations. We have, I'm sorry, I got distracted here. I'm not, am I on?
Yes, you are.
I am, okay. I'm not seeing it and saw another face there. I'm sorry, I don't have my notes, which I usually have right here. But we've asked Deborah Bunkley to come in and introduce the league. So Deborah will come on in a minute. You were brought into this program with your sound off and your mic off and your camera off. At the end, you're welcome. If you want to ask questions directly, we can do that. But throughout the program, you're welcome to put your questions in the chat. And Ruth Coolwin will capture the questions and ask them at the end of the program. Deborah?
Oh, okay.
I'm
wasn't
sorry.
sure.
I was rattling on because I remember my script.
Okay, well, I don't have my script, but I do know some things by heart. Hello and Happy New Year, everyone, first of all, and welcome to our forum. I didn't realize we had been doing this for 5 years either. I'm the communications director for the Detroit League of Women Voters. We also have Hamtramck and Highland Park. And in the beginning, I like to say, remember that democracy is not a spectator sport. And as we move forward with a new president coming into office, I want to remind everyone that the league is nonpartisan. We don't get behind any candidate or positions. We do advocate for some things, and you can look that up on our league page, which is lwvdetroit.org. I want to mention that we have a play that we're having on Sunday, the 19th. It starts at 12 o'clock. It's Ma Rainey, August Wilson's play. It is one of our largest fundraisers, and this is the third time. So please, I think most of our tickets are sold, but you can check with that. We also welcome anyone to join our league. We are federal, state, and local, Hamtramck, Highland Park, and Detroit. And I just want to say on behalf of the last voting that the league, we did a great job. We had, we registered, I can't tell you how many people we registered. Thank you, Betty. We had forums. We did everything. We did made sure that people got rights to the polls. People came out and voted, and that's what we represent: registering people to vote and making it easy for folks to vote. And as you can see, it didn't turn out the way some people wanted, but people came out and voted, and that's what we represent. So enjoy the forum that we have tonight with for the library. And on behalf of the Detroit League of Women Voters, I want to remind you that democracy is not a spectator sport, and we will be challenged as we move forward. Thank you.
Thank you, Deborah. Well, we're very pleased to have Phil Mayer here tonight, and I've covered up my text. I am trying to do too many things all at once. I'm sorry about that. He is with the ACLU of Michigan. He joined the ACLU in 2019. He litigates across a broad range of issues, including criminal legal reform, voting rights, racial justice, surveillance and the Fourth Amendment, prisoners' rights, free speech, and religious liberties. He was named one of Michigan Lawyers Weekly's Leaders in the Law in 2023. Tonight, he is going to be talking to us about recent cases in the Michigan Supreme Court. Phil?
Thank you, and thank you to both the Detroit Library and to the League of Women Voters for for this invitation and for the chance to talk about the Michigan Supreme Court and what it does and the role it plays in our democracy and our legal system. I'd also just like to echo Ruth's comments about the election. One of the many areas that I litigate in is voting rights. I'm one of the lead voting rights attorneys at the ACLU of Michigan, and we work closely with the league in a lot of that work. And this election, there were a lot of things to worry about going into it, about whether it was going to be respected, how it was going to be run, and it was a smooth, cleanly run election, regardless of how one feels about the results. And there were so many things that we were paying attention to and worried about. And I just want to say, like, the voting part worked. So I really agree with that. The Michigan Supreme Court. What is the Michigan Supreme Court? What does it do? And to sort of start that, I want to kind of talk a little bit about. Oh, and sorry, by the way, this looks like a pretty small group. So I would encourage, if folks have questions, I'm able to monitor the chat in pretty real time. But if you just want to stick up your hand on the reaction button, I can answer questions as we go. I'd be happy to keep it informal and speak to whatever people are interested in. So in thinking about the Michigan Supreme Court, I think it's helpful, first of all, to just kind of baseline with how the constitutional structure of the United States and of Michigan works. When we talk about constitutional rights, many people think of the Bill of Rights in the federal Constitution, and don't necessarily know how that interacts with state constitutions. So, in this federated republic, we have not just the federal constitution, but every state also has its own constitution, and of course, Michigan is no exception. So how do these constitutions interact? The best way to think of that really is that the federal constitution sets a floor for people's individual rights and liberties, but not a ceiling. So state constitutions can go further. Also, the federal constitution sets up a structure for the federal government. It deals out power between the legislative branch, the executive branch, and the judicial branch, but it doesn't set a rule for how the states can divvy up that power. So the states aren't necessarily bound to follow the way that the federal legislature or the federal constitution carves up the power amongst the different branches of government. So just to take a couple very simple examples, there's one state that has a unicameral legislature, right? The state of Kansas has a unicameral legislature. They don't have a Senate and a House. They just have one House because they've set their state constitution up that way. There's plenty of other examples of that, and that's not really a floor versus a ceiling thing. That's sort of that each state within the minimum parameters set by the federal constitution can set up their constitutional structure the way they want to. So what are some examples of each of these things? In terms of the federal constitution setting a floor, an example there is the U.S. Constitution was amended in the wake of the Vietnam War to make the voting age in the United States 18 as the minimum age. You're guaranteed to be able to vote in federal elections at age 18. Michigan's Constitution says you only acquire the right to vote at the age of 21. Well, Michigan's Constitution is preempted or surpassed by the U.S. Constitution because the U.S. has set that floor. It has said you have the right to vote if you're older than 18. So even though Michigan's Constitution says 21, Michigan's Constitution in that regard has to be sort of disregarded. But there are many other places where the Michigan Constitution says something different than the federal Constitution, and that's okay because it's just going further than the federal Constitution. To take an example that would be of interest to this crowd, Michigan's Constitution actually has a constitutional right to libraries and access to libraries. It's Article 8, Section 9 of the Michigan Constitution. I actually once thought about bringing a case under that provision, which I didn't get to bring, I'm disappointed to say. But there's obviously no constitutional right to libraries anywhere in the federal Constitution, but Michigan's Constitution has guaranteed that right. That's sort of a place where the Michigan Constitution expressly includes something that the federal Constitution doesn't. But then there's places where the Michigan Constitution may be interpreted to mean something that the federal Constitution doesn't. And that's where the Michigan Supreme Court comes in. So when you think about the different constitutions, you also have to think about the different courts and what their authority is to decide questions under those constitutions. So for the US Constitution, everybody knows the United States Supreme Court is the highest authority. They interpret the language of the United States Constitution and they say what it means. And every court in the country, whether it's a state court or a federal court, is bound to follow that interpretation. But and that means, so cases that involve federal constitutional rights can come up in Michigan's state courts. So you can file a case about federal constitutional rights in Michigan courts. And if you file it in Michigan courts, the Michigan Supreme Court will eventually hear that if the Michigan Supreme Court thinks the issue is interesting enough to hear. But when the Michigan Supreme Court hears a case about the US Constitution, it has to follow the US Supreme Court's decisions, and it has to attempt to interpret the US Constitution in a way consistent with how the US Supreme Court would do that. And when the Michigan Supreme Court decides a case like that, its decision can be reviewed by the United States Supreme Court. So it can be overturned or affirmed by the United States Supreme Court. But something different happens when the Michigan Supreme Court interprets the Michigan Constitution. The United States Supreme Court doesn't have any jurisdiction over the Michigan Constitution because it's not a Michigan court. So if a question comes up under the Michigan Constitution, the Michigan Supreme Court is the highest and ultimate authority that will decide what the Michigan Constitution means. So a minute ago, I was talking about the constitutional right to libraries. If a constitutional issue comes up about that and the Michigan Supreme Court decides it, that's over, it's done. The US Supreme Court can't look behind that, can't overturn it, can't overrule it, unless something that is said in that decision is inconsistent with the United States Constitution, meaning prohibited by the United States Constitution. That matters a lot if you're somebody sitting in my shoes right now. So without being partisan, you know, we at the American Civil Liberties Union, we try to litigate to protect people's constitutional liberties. And my perspective on the federal courts is that we are in an era when federal courts are being less and less protective of our constitutional rights and are cutting back on constitutional rights that have been established in case law for decades or even centuries. So if you're in my shoes and trying to litigate and protect the constitutional rights of Michiganders, you're looking to say, do I want to bring a case under the federal Constitution where the ultimate body that reviews it is going to be a Supreme Court that has turned in many ways against constitutional liberties? Or do I want to bring that case in the Michigan Supreme Court with a court that is, at least in its current formation, showing much more sympathy for the constitutional liberties of Michiganders? So a lot of my, in the 6 years that I have been working at the ACLU, in that short time, a significant portion of my work has actually shifted towards the Michigan Supreme Court and litigating cases under the Michigan Constitution. So I said earlier, you know, there's things like the library right that is explicitly in the Michigan Constitution that isn't in the federal Constitution. But what are some examples historically of some rights that Michigan courts have found differently? So one example is the constitutional right against improper searches and seizures. So most people know that this is, if they know their federal constitutional right and their Bill of Rights, that this is a right protected by the Fourth Amendment to the United States Constitution, but it's also protected by the Michigan Constitution. And in the 1980s, might have been 90s, there was a case called Sitz. Sitz went up to the United States Supreme Court on a federal theory. Sitz was about whether or not suspicionless stops for breathalyzer tests were constitutional. And people were arguing that it's a search and seizure. Your car is stopped and you are searched by giving a breathalyzer test, and that's not authorized by the United States Constitution, by the Fourth Amendment. The United States Supreme Court heard that case, and it said, no, actually, we're going to say that this is a lawful search under the United States Constitution. So it sent the case back down, and the Michigan Supreme Court said, well, not so fast. We hear you. The United States Constitution does not protect against this particular warrantless search and seizure, but we're going to say that the Michigan Constitution does. Even though the language is quite similar about searches and seizures in the Michigan Constitution, the Michigan Supreme Court at that time interpreted the Michigan Constitution in a more protective way with respect to the right against warrantless searches and seizures. Another example, and this is going to come up a few times in the talk this evening, where we see this, is many people are aware that the Eighth Amendment to the United States Constitution protects against cruel and unusual punishments. Well, Michigan's Constitution says something slightly different. It protects against cruel or unusual punishments. Maybe that's a big deal, maybe it's not. But Michigan courts have said that that is a big deal, and that means that the Michigan Constitution is more protective of the type of ways that we can punish people. And we'll talk about a really important way that's at issue this term, in which Michigan courts have done that. I also want to just talk about the difference in how the courts are composed and appointed and how that works before jumping into some cases and some specifics. The United States Supreme Court, as I think is pretty well known, is composed of 9 justices, all of whom are appointed to lifetime appointments. So they can't be fired. They step down when they want to step down. And I think it's well established at this point that most of them tend to step down under presidents who they believe to be sympathetic with their politics, to try to ensure that they are replaced by somebody who is similarly minded. Michigan's system works a little differently, although there are some similarities. First of all, we have 7 justices, not 9. And as the League of Women Voters knows well, those justices are on the ballot. With that said, there's in some ways more commonality than people think. So justices serve 8-year terms and then have to be reelected. It's not a lifetime appointment. And in fact, they can age out. Beyond certain ages, they can't continue to serve. But one way in which it's more similar to the federal system than it looks is that if a justice steps down partway during their term, the governor can appoint a replacement. And in fact, the governor can appoint a replacement without nearly as much process as goes into the United States Supreme Court appointments, where there's a whole senatorial confirmation. So that means that Michigan justices can still, in some ways, do what the United States Supreme Court justices do by stepping down during an administration they believe is sympathetic with their personal judicial views, and having someone appointed in their place. And that really matters when it comes to the time of judicial elections, because as important as judicial elections are, and though sometimes a sitting justice is knocked out during an election, traditionally, because the word justice is included when somebody runs for re-election, somebody who is a sitting justice has a very, very strong incumbency advantage. And we don't see it happen very often that somebody who is a sitting justice loses their seat. For those counting political noses, although the seats, when they run for the Michigan Supreme Court, it doesn't list whether you're Republican or Democratic affiliated. The seats are nominated by the political parties. And so it's generally known which party a justice is more affiliated with. The current composition of the Michigan Supreme Court is that there are 5 justices most affiliated with the Democratic Party and 2 justices most affiliated with the Republican Party. That was a shift in the most recent election. Prior to that, it was a 4-3 court. It is now a 5-2 court from that perspective. Of course, as with the United States Supreme Court, the justices, you definitely cannot always predict a justice's vote based on their political party. But as also with the United States Supreme Court, in highly political cases, cases where, in particular cases involving the constitutional rights of the type that I litigate, often somebody's political predilections are very important to understanding how they might come out. Before I move on to my next topic, which is amending the Constitution, I do want to just kind of pause and ask if anybody has any questions or anything they want to say about sort of the structure of the courts and the Michigan Supreme Court as compared to the United States Supreme Court. Looks like Cheryl might have a question.
The question is, what are the rights of the kind of ethic rights? I mean, is there anything in writing in Michigan about our ethics? I know the Supreme Court has sort of a watery kind of stance, but
That's a great question. There is a code of conduct, a code of judicial conduct in Michigan that applies to Michigan's justices. I'm not, to be honest, sure how it's enforced. For lower court justices, there's a judicial tenure commission that can sanction lower court judges in Michigan, and then those decisions are reviewed by the Michigan Supreme Court. So I'm not sure what the enforcement mechanism is. That's a question I'll have to look into. I also see that Lisa has put a question into the chat about the current makeup of the United States Supreme Court. And the answer is that court is currently 6-3 majority appointed by Republicans. So it's a very different situation we see with the United States Supreme Court that leans quite conservative, and actually leans about as conservative as we have seen, certainly as we have seen a Supreme Court in my lifetime or the lifetime of anybody who could possibly be on this call. The last time we saw a Supreme Court that was as conservative is generally believed to be before the New Deal in sort of the 1920s. Is the last time we saw a court as conservative as the one we see now at the federal level.
Wow.
So it's when I said that as somebody who urges for strong interpretations of people's civil rights and civil liberties, I'm looking in state courts. That's a lot of why, because the United States Supreme Court has really turned in a very strong way right now against civil liberties, or at least against most civil liberties. There are certain places where that is not true, but for many of the rights that I find myself arguing in favor of, the state court is a much more friendly environment.
There's another here.
So yeah, Greg has a question. Why are Michigan Supreme Court candidates nominated by political parties? I don't actually know the answer to that. I just know that they are. But it is on the ballot in nonpartisan positions, so there's no R and D next to the names, but they are nominated at the nominating conventions for each respective party. Lisa asks, so is it the case that once a decision is determined by the state Supreme Court, there's no chance for that decision to be overturned by the United States Supreme Court? The answer to that, as lawyers love to say in response to questions, is it depends. If the Michigan Supreme Court can consider 2 types of cases. It can consider cases of Michigan law, or it can consider cases of federal law. When the Michigan Supreme Court considers an issue of federal law, it's bound by federal case law, and in particular, it's bound by United States Supreme Court case law. And when it decides a federal question, the United States Supreme Court can review what the Michigan Supreme Court has decided, because that's a federal question that ultimately the authority to interpret the federal Constitution belongs to the US Supreme Court. But if the Michigan Supreme Court is making a decision interpreting the Michigan Constitution, the United States Supreme Court cannot review that decision, because the United States Supreme Court is not the top authority interpreting the Michigan Constitution. The Michigan Supreme Court has that authority. The one tweak to that answer, Lisa, is that sometimes the United States Supreme Court could say, well, Michigan Supreme Court, your interpretation of the Michigan Constitution is such that it now violates the United States Constitution. And in that case, they could still review the Michigan Supreme Court interpreting the Michigan Constitution, but only in that limited way.
Phil,
These are great questions.
excuse me, Phil, this is Jennifer.
Uh-huh.
If you prefer to have people talk rather than put the messages in the chat, they can raise their hands and we can unmute them if you would rather do it that way.
Yeah, either way, however people prefer to answer questions, I can handle them orally, or I can read them out of the chat. Estelle Duncan asks, is there a way to remove Supreme Court judges? If you mean United States Supreme Court judges, the answer to that question is through the impeachment process in the Senate. So it's possible, but extraordinarily rare and difficult to do, and requires supermajorities. And I should know the answer to that question under the Michigan Constitution, but I actually don't. So I've got a couple of pieces of homework from the really great questions that are coming in. So thank you for that. So the next thing I wanted to turn to before talking about some individual cases, both this term and next term, is amending the constitutions. One of the things that is very, very different between the United States and the Michigan Constitution is how they are amended. Many of you probably know that the United States Constitution is extremely difficult to amend. It's only been done a handful of times in the more than 250 years that since 1789 that the Constitution was enacted. It requires a supermajority of the legislature, and it requires a supermajority of the states, both working together to amend the United States Constitution. So we just haven't seen it happen very often, and we don't see it happen very often. By contrast, the process for amending the Michigan Constitution is a lot easier. Especially, those of you affiliated with the League of Women Voters on this call probably don't need reminded, but we have seen this quite a number of times in the past few years. The most common way of amending the Michigan Constitution, actually, first of all, let me say the Michigan Constitution itself has been rewritten about 5 times. So the most recent Michigan Constitution is the 1963 Constitution, but there were several versions of the Constitution before that. I think we're on our 4th, 5th, or 6th Constitution at this point, where we've had a convention and just rewritten it completely. But in terms of amending it, it can be amended by popular referendum, and by popular referendum you need, I want to say it's 8, it might be 10, forgive me, % of the number of voters who voted in the last federal election to sign an initiative to put a constitutional amendment on the ballot. So that's a big deal. That's really hard to do. We at the ACLU have been involved in campaigns to put an initiative on the ballot because getting hundreds of thousands of signatures in a limited time frame isn't an easy thing to do. But it's a lot easier than amending the federal Constitution. And once that happens, an amendment can be put to the voters, and by a majority of the popular vote, the Michigan Constitution can be amended. So we've seen this happen 4 times just in the most recent elections. Particularly as relevant to this crowd, it's happened 3 times with respect to voting rights in Michigan. In 2018, the voters of Michigan enacted the proposition that currently guides our redistricting. We went from a partisan system for drawing district lines, in which it was pretty easy to do a major partisan gerrymander gerrymander to having the current system whereby it's drawn by a citizen commission. That was done by popular referendum. And then in 2018, we had the Promote the Vote popular initiative to amend the Constitution, and that guaranteed quite a number of voting rights in the Michigan Constitution, most notably the right to absentee ballots, no-cause absentee ballots, which was huge, of course, when COVID hit, and all of a sudden people needed absentee ballots. And then in 2022, the Michigan voters again amended the Constitution to further protect voting rights, and in particular to enshrine an explicit fundamental right to vote in the Michigan Constitution, and a cause of action for lawyers like me to enforce that. And that also codified a number of further protections for the right to vote. And then also, I think very famously, I imagine nobody on this call doesn't know, in the wake of the United States Supreme Court's overturning of Roe versus Wade, in which the United States Supreme Court held that the federal Constitution doesn't protect the right to an abortion, a reproductive choice, the voters of Michigan enacted an amendment, Proposition 3, to the Michigan Constitution to expressly guarantee the right to reproductive freedom in Michigan. And that is now a right that I litigate under, and that is a right I litigate under in the Michigan courts. And those cases will ultimately be decided by the Michigan Supreme Court without somebody being able to go to the United States Supreme Court to ask for further review. So that's where this difference between the Michigan Supreme Court and the state Supreme and the U.S. Supreme Court matters so much is in something like that.
And there's a question from Greg, Phil, regarding the federal Supreme Court. For the Equal Rights Amendment, if President Biden sends it to be published, will it really become an amendment to the U.S. Constitution, or could the U.S. Supreme Court block it with the issue of the time limit Congress included in the original action?
Yeah, well, Greg, you've asked the right question, and you've identified the right tensions. This is an unresolved question of federal constitutional law as to what would happen. Certainly, if President Biden publishes it, there will be a constitutional challenge, and federal courts will have to decide. And I'm sure the United States Supreme Court would have the last word as to whether or not. For folks, let me give a little bit more background for folks that don't know this issue in and out. In the 1970s, the federal legislature approved an amendment called the Equal Rights Amendment that would more expressly guarantee than it already does rights to equal rights based on gender in the United States Constitution. That the next step is that it had to be approved by 3/4 of the states. But Congress, when it enacted that, did a funny thing. It said that the amendment had to be approved by the states within a certain time window. And that didn't happen. But recently, the last states to make a 3/4 majority have approved the Equal Rights Amendment. So there's now more than 3/4 of the states that have approved the Equal Rights Amendment. And so there's a question, if President Biden publishes the amendment, whether or not it can then be codified in the United States Constitution. So that's the issue Greg is asking about. There will be litigation about that if it happens, and I can't with confidence predict what the result of that litigation will be. There's certainly an argument that the legislature isn't allowed to, or that the federal Congress isn't allowed to add a time block on the right of the people and the states to enact an amendment. On the other hand, they did it, so there's a question of how, or at least they purport to do it. There's a question of how the courts will decide that. And I don't know, in response to Lisa's question, what the Biden administration's view or what they have said about it. I haven't been tracking that. So with all of that said, I'd like to turn to some of the really interesting nuts and bolts. What does this actually mean? What has the Michigan Supreme Court been up to recently? And what are they up to this term? And most of my talk is going to be focused on, not surprisingly, issues involving civil rights. There's lots of other things that the Michigan Supreme Court decides, but I litigate the most about constitutional rights, and all of the cases I'm going to talk about are either cases I've been involved in or that the ACLU has been involved in some way. So there's many others. This is just sort of the universe of cases where I'm most focused and most knowledgeable. One area where we have seen the Michigan Supreme Court moving in a, I think, very positive direction in the past few years is on access to the courts. If you care about civil rights and civil liberties, there's literally nothing that matters more than whether or not people who want to sue about civil rights and civil liberties can even get in the front door to the court. And if you're a civil rights litigator like me, you spend as much, if not more, of your time arguing about whether or not you're allowed to be in court than you do arguing about the actual merits of the claim you want to bring. There's doctrines called standing, called mootness, called ripeness, whether or not you have a cause of action. All of these things you spend so much time fighting about. And in a case a few terms ago called Bowserman, the Michigan Supreme Court made a huge movement on this. So in Bowserman, the issue was about the ability to enforce the Michigan Constitution for damages. Believe it or not, in as long as Michigan has been around as a state, nobody had ever definitively answered the question of when and under what conditions you could sue in Michigan to get damages, money, in other words, for when your constitutional rights under the Michigan Constitution have been violated. This question is answered under the federal Constitution. We know when you can go into federal court to seek damages against a federal agent who has violated your rights. But this question in Michigan of when you could sue a state official for violating your rights under the Michigan Constitution had never been decided. And it's complex because there's all kinds of immunities and structural questions involved. And in this case called Bowserman, Bowserman was about an incident that people might remember, which is back in 2014. The state government, the state unemployment agency, adopted some software, some like artificial intelligence software that started making judgments about whether or not people had submitted fraudulent applications for unemployment insurance. And it started taking away people's benefits or sending out notices telling people they were accused of fraud, and basically adjudicating that in a way that deprived people of their right to due process. And those people sued, and they sued the state government under the state constitution and said, you're violating our due process rights under the Michigan state constitution, and you've ruined our lives. People went bankrupt. People had their wages garnished. Some people committed suicide from the financial impact of their family of these unexpected financial hits. I mean, unemployment is meant to lift you up at a time when you're vulnerable, and instead what had happened is people were getting punched down. So they sued. And this went all the way up to the Michigan Supreme Court. And in this case called Bowserman, the Michigan Supreme Court said for the first time in clear and unambiguous language that yes, there is a right under the Michigan Constitution to seek damages, to seek money when the state has violated your state constitutional rights. This is really, it's a watershed ruling that makes, to someone like me, all the difference in the world for our ability to hold the government accountable when people's constitutional rights are violated. It means we can go beyond just going into court and asking for a court to say stop violating people's rights, but we can get people compensation for the harms they've suffered. That in turn provides really important incentives for the government to play it straight and not violate people's constitutional rights in the first place. So that's just an absolutely huge case that the Michigan Supreme Court decided recently that we were involved in. There's another case about access to courts that the court will be considering this term. There's a case called Michigan Republican Party versus Benson. And those who associate the ACLU with kind of left-wing causes may be a little surprised at what I'm about to say, and I think it demonstrates how what you might think about the partisan nature of cases isn't always the nature of the cases. This is a case, I actually don't think it's a very meritorious case, but it was a case where the Michigan Republican Party sued Flint and said, Flint, you are not doing enough under state law to ensure that there is a partisan balance among poll workers in the Flint area. And instead of reaching the merits of that claim and deciding whether or not Flint was doing enough to have a partisan balance, so enough Democratic affiliated poll workers and enough Republican affiliated poll workers, the court kind of dodged that question. And the court instead said, the Michigan Republican Party doesn't have standing. Standing is a concept that basically says, are you the right person to be bringing a case in court, or should somebody else be bringing it? and so the courts below, the lower courts in Michigan, said the Michigan Republican Party doesn't have standing to bring a case like this. They said county level political parties have to bring that case. So I said earlier that if you're someone like me, you spend as much of your time fighting about things that aren't the merits of the case, but about like whether or not you can get into court in the first place. I spend so much of my time in federal court fighting about standing. The federal courts have erected a number of doctrines that make it increasingly hard for somebody to come into federal court and sue about their rights. And they say that you're not the right person, somebody else has to do it, but then finding that person's really hard too. This is one of those areas, standing, where the state Supreme Court has gone a different way. They have said that's all well and good for federal courts who are interpreting the scope of the judicial power for federal courts, but we here in Michigan, we have more generous rules. In general, if there's a real controversy between people who have a serious skin in the game, we're going to adjudicate cases. So this case I've been describing with the Michigan Republican Party about partisan balance for election inspectors, poll workers, is one where we don't necessarily think that the Michigan Republican Party has the right position at the end of the day about whether or not they should win on the poll worker issue, but we do think that they have a right to have this adjudicated. Who is better situated or more appropriately situated to litigate a question about whether or not there's enough Democrats and enough Republicans working in the polls than a major political party? We at the ACLU just think it's a crazy position to say like they don't have skin in the game. And so this is a case where we have filed a brief in support of the Michigan Republican Party before the Michigan Supreme Court, saying, Michigan Supreme Court, this is a chance for you to reaffirm the principles that you have previously stated, that Michigan's courts are open and doing business for people who have serious questions about their rights and responsibilities. And if the Michigan Supreme Court decides this case the way that we are urging them to do, and we hope that they do, that'll reinstate the Michigan Republican Party's case. And then they'll have to go back down to lower courts and they'll have to litigate whether or not they're right about the underlying legal question. But from our perspective, it will help ensure that the doors to Michigan's courts are open for all of the other types of claims that we have to bring. Claims about people's right to an abortion, claims about people's right to freedom of speech and religion and all of the things that we litigate around. So that's a really big case to keep a lookout for this term. It's called Michigan Republican Party versus Benson. It's not versus Benson. It's versus Donahue. Sorry. Got that wrong in my notes. Deborah Bunkley asks, will I elaborate on the redistricting case? Deborah, can you come off mute and maybe say what case you have in mind? Oh, she was off mute for a second.
Deborah, you do have the ability to get off mute.
Okay, I'm off. Okay, hello?
There you are.
Hello.
I just wanted you to bring bring to the attention of how difficult it was for the redistricting committee, since it was the first time that people have actually had a voice in drawing their own maps, how it was literally controlled by party, the two different parties. And Susan Smith was the league's leader in that. So I just wanted you to speak to the fact that, the importance of it, I guess, how important it was that we got to draw on the maps, even though the original, the ones that they drew after we won the case was the perfect landscape for maps. And then, talk a little bit about what happened and how, we had to go back and redraw them. And first of all, number one, how much money was spent.
Sure.
And not a lot of people showed up. So
Sure. So that's a really rich question, and there's a whole lot to talk about there. So just to provide the background, I mean, first, I think one of the things you're asking me to comment on is sort of how much of a difference redistricting, nonpartisan redistricting made, and the answer there is it's huge.
yeah,
One of the many areas in which the United States Supreme Court has not been very supportive of people's voting rights in the past years is that the current United States Supreme Court has held that partisan gerrymanders, no matter how naked, no matter how partisan, no matter how disadvantageous, are not an area that they will consider. They just won't hear cases about it. They say it's a political question and courts aren't going to get involved. And what that means is if you can draw incredibly contorted, twisting lines so that you can lock in a supermajority with less than 50% of the vote, you can do that. And we've seen that happen in a number of states, and we saw that being the case here in Michigan for years and years and years, where from 2010 onwards, the maps had been drawn in a deeply partisan way that made it essentially impossible for one political party to get a majority in the state legislature unless it won a supermajority of voters. I think the numbers were something like, in most cases, it would probably require getting like 58% of the vote or something like that in order to have a simple majority under the partisan gerrymandered maps we had from 2010. So the Independent Redistricting Commission changed that, and it said now maps will be drawn by a citizen commission, which will be drawn by some citizens affiliated with the Democratic Party, some citizens affiliated with the Republican Party, and some citizens who are unaffiliated independents, and they form a commission. Part of what you're also alluding to, I think, Deborah, is there was complexity, and those of you who followed the news will know this, around the drawing of those maps. Those cases weren't actually cases decided in the state courts. The cases around that were mostly, the major cases were federal cases. And essentially what happened is the Independent Redistricting Commission drew its maps. And in redrawing the maps, one of the things they were looking at was race, which is appropriate to consider race in drawing maps because the Federal Voting Rights Act says you're supposed to make sure that maps aren't being drawn in a way that disadvantages racial minorities. But a federal court basically said, like, you considered it in the wrong way. You considered it too much in some places and not enough in other places. Go back and redraw the maps. So to redraw some of the maps. They had to redraw some of the districts. And the issue there where they were primarily districts in Detroit and the area around Detroit, where the commission thought they had done a sufficient job of drawing districts that would protect the rights of Black voters to elect candidates of their choice, and where it hadn't really played out that way because of the way primaries worked out, and so those some of those seats were redrawn. I will say under either of the contested maps, regardless of how people felt about that particular decision, both maps were far, far, far more calculated to ensure partisan balance. And those cases were about whether or not federal law was being complied with in terms of race and the way race can be used in redistricting. Does that answer your question, Deborah?
yes, thank you. You said it so much better than I ever could.
My pleasure. Well, then turning back to the Michigan Supreme Court and what they're up to, let me draw attention to another area where the Michigan Supreme Court has really been moving quite a lot in recent years, and where we're looking to see if there will be more movement this year and in upcoming years. And that's the area of juvenile life without parole sentences. As folks may know, and as the words themselves suggest, a sentence of life without parole is a criminal sentence that is imposed in which you have no possibility of parole. You're sentenced, and from the day that you are sentenced, you will die in jail. End of story. That's it. That's what a life without parole sentence means. And in a series of cases dating back to about 2010, the United States Supreme Court, in interpreting the federal cruel and unusual amendment, so the 8th Amendment to the United States Constitution, which prohibits cruel and unusual punishments, increasingly protected the rights of juveniles not to be subject to these sentences. First, in about, I might have my years a little bit wrong, but around 2010, the United States Supreme Court said, we're going to hold that it's unconstitutional, it's cruel and unusual to sentence a juvenile to the death sentence. And they said that's because of the nature of decision making when you're a child, that your brain is not fully formed. And whether you're talking about deterrence or whether you're talking about retribution, the two kind of reasons that we justify punishment, we can't justify the death penalty for someone who committed a crime when they were a child, no matter how heinous the crime, in light of the fact that people's personalities and brain functions aren't fully formed. Then a few years later, the Supreme Court extended that reasoning, and they said, for the same types of reasons, we're going to say it's not constitutional to impose an automatic sentence of life without parole for non-murder offenses for juveniles. And then a couple years later, they said, actually, we're going to say the same thing for murder offenses. Now, what they didn't say you can never impose a sentence of life without parole on a juvenile. But they did say it can't be automatic. So the criminal law can't say if you're convicted of murder, first-degree murder, you will get a life without parole sentence for juveniles. Juveniles have to have a chance to argue that the nature of being a child, of their background, of their reduced maturity, and they have to have a chance to make those arguments, and that a sentence of life without parole has to be very rare. That's what the United States Supreme Court said. And the United States Supreme Court, so that applies to the whole country, that applied in Michigan. But in recent years, the Michigan Supreme Court has gone further. The Michigan Supreme Court, in a case called Parks, a few years ago, said, all those same reasons about brain formation and maturity that apply to 17-year-olds and 16-year-olds and 15-year-olds actually apply to 18-year-olds too. Because the science on this, if you get into the science, is we start sort of locking down our brain formation and our maturity levels actually around the age of 25 in our early to mid 20s. And so the Michigan Supreme Court said, we're not interpreting the federal cruel and unusual provision. We're interpreting the state cruel or unusual provision. And in the state provision in Michigan, under Michigan's Constitution, you also can't automatically impose a life without parole sentence on 18-year-olds. As I just said, the science on this shows that we sort of acquire our personalities and full brain formation and maturity and ability to sort of make judgments about risk and reward in our early to mid 20s. So we at the ACLU are like 18 that's good, but it should go further. And indeed, the Michigan Supreme Court will be considering two really important cases called Sarnecki and Taylor this term, where they will be considering respectively whether or not that same reasoning applies to 19-year-olds and 20-year-olds. So if those cases come out the way that the ACLU is encouraging, then that would mean that in Michigan, it will no longer be constitutional to automatically impose a life without parole sentence for up to 20-year-olds. I will also say that we at the ACLU have encouraged the Michigan Supreme Court declined to hear a case last term, but we hope this isn't the end of the story. We encourage the Michigan Supreme Court to go further than the federal Constitution has gone and say, instead of this like complex, the sentences have to be rare thing, we should just say there should never be a life without parole sentence. You know, re-examining things in 25 years when somebody has committed a crime as a juvenile is like, that's fair. We can do that. So we have urged the Michigan Supreme Court to do that. They don't currently have a case on that on their docket, but that's something we'll be looking out for in the future to see if we can get that issue up to the Michigan Supreme Court. We would really like to see them reach that issue. And then there's also another important case about juvenile life without parole this term called Poole. And Poole is really important because I mentioned this Parks case that decided that 18-year-olds are entitled to the same constitutional presumptions as 17-year-olds and 16-year-olds. Poole will decide if that Parks decision is retroactive, meaning does it only apply to people, to children, to 18-year-olds sentenced in the future, or does it apply to 18-year-olds who were sentenced 25 years ago for them to have a chance to go back and say, look at me again now? So the Michigan Supreme Court will be deciding that this year. And Lisa's asked me to put the names of these cases in the chat. Just one moment, I'll be happy to do that. The case I just mentioned about retroactivity is Poole, P-O-O-L-E. And the two cases about 18 and 19-year-olds are Sinerki, I have no confidence that I'm pronouncing that right, and Taylor. They're in the chat now. So this is a really big area. It's an area where the Michigan Supreme Court has gone well beyond what the United States Supreme Court has done under a really important Michigan provision, the cruel or unusual clause, and where they're really leading the nation in taking these insights about the nature of young people committing crimes seriously. I want to another area where the Michigan Supreme Court has been very active, which is of course very important to this audience, is in the area of voting rights. I want to talk about two cases. One of them is just about Michigan law. One of them is actually, you know, we talked earlier about how the Michigan Supreme Court can decide questions of federal law too. And the Michigan Supreme Court did that, decided a case of federal law, but it was a case, it's really a nation-leading case, and it's a case that we at the ACLU were heavily involved in earlier this year. And that case was called People versus Berkman. And People versus Berkman was a really, really interesting case. That case was about this guy Berkman and a Confederate of his during the 2020 election had perpetrated a really, really perfidious scheme. They had made fake robocalls that were designed to sound like they were from somebody who sounded a whole lot like Breonna Taylor's mother, but was not in fact Breonna Taylor's mother. And they called, they directed these robocalls to voters in majority Black areas in swing states in the midst of the 2020 election, which was also, of course, in the midst of COVID. And these calls said, did you know that if you vote by an absentee ballot instead of in person, you will be put on the list for warrant checks, for mandatory government vaccinations, and for debt collections. So it said, don't vote absentee, go vote in person. Of course, in the height of COVID, this could only be taken as a way of deterring people from voting. And again, they targeted this at majority Black jurisdictions in swing states. So it's pretty clear what they were trying to do with these calls. The Michigan Attorney General brought charges against Mr. Berkman and his Confederate, Mr. Wool. And they essentially said, you are engaged in election fraud, and this is criminal, this is a felony. And Mr. Berkman and Mr. Wool had an interesting defense. They said, no, we have a First Amendment right to talk about elections. And we were talking about elections. This is political speech. So this case went up to all the way to the Michigan Supreme Court. And the ACLU played a really interesting role here because we agreed with the Attorney General that these individuals were not engaged in protected speech. But with that said, the First Amendment generally actually does protect a lot of dishonest speech. Everybody who's ever lied will be happy to hear that for the most part, dishonest speech, if it's not really attempting to actively defraud somebody, can be protected. And the Michigan Attorney General was taking what we thought was a very dangerous position. She wasn't just saying that their speech could be prosecuted. She was, and I'm simplifying a little bit, essentially saying that because their speech was dishonest and could deter people from voting, that it could be prosecuted. Or just because it scared people and could stop people from voting, it could be prosecuted. And we said, wait a minute, that's a dangerous theory. That would mean that Malcolm X giving a speech that says, the United States government is out to get you, hold your vote and save it for people who actually deserve it, is trying to scare people into not voting, and could be prosecuted by a hostile government. So the ACLU came into this case with a different position. We came in and said the Attorney General's right. She can bring a case against these individuals and charge them with a felony, but her theories under the First Amendment are wrong, and they're dangerously overbroad, and they could be used in the future to prosecute people for engaging in protected political speech. We filed what's called an amicus brief. It's basically where you're not a party to a case, but you file as a friend of the court. The League of Women Voters files a lot of amicus briefs as well, some of them with us. And we said, you need to adopt a narrow test for why this type of speech is not protected. A test that focuses on the fact that these weren't just lies, because people lie all the time in politics and if you could prosecute your opponent in every election because they said something you thought was dishonest, like every election is being decided now in the courts. We said what's unique here is that they're not just lying about an election. They're lying about the time, place, and manner or actual ways that you go about voting. And that is not the type of lie that has useful social value, or where we can sort of identify those lies as unique, and you can prosecute somebody for those lies. And that's actually the position that the Michigan Supreme Court adopted. They essentially adopted the test that we urged. This is just such an interesting case because it sits, for me as a constitutional lawyer who cares about people's constitutional rights, it really presented this sharp, not conflict, but really difficulty in sussing out two very important things: our free speech rights and our right to vote freely and fairly. And we think the court got it just right in a really hard case where it's easy to make a mistake in either way. So I just, this is not one of those cases that's under the Michigan Constitution. This is a case that in principle, the United States Supreme Court could have reviewed. They were not asked to review it, so they have not. And when you ask the United States Supreme Court to review a case, they don't review many cases anyways. So this is the final word in Michigan for now, but it's a really interesting and important issue, and this is going to play out in all kinds of ways with the rise of AI and dishonest speech around AI across the country. And the Michigan Supreme Court's current decision, this Berkman decision, is one that's going to be a landmark, and I'm really interested to see what happens with it in upcoming years. Greg asks, would changing all Michigan elections to ranked choice voting need a Michigan constitutional amendment? To which I would say we have there are some conflicting legal theories on that, and I don't at this point want to go on record one way or another about that. But there may be some forthcoming developments on that in the upcoming years. It's certainly that question hasn't been definitively answered.
He has another question too. Is the ACLU at all involved in Michigan's fake electors case?
You mean the criminal prosecution of the fake electors from 2020?
I believe so.
Yeah, we have not been involved in that case. So another really important case from the Michigan Supreme Court around voting rights last year, in which we also submitted an amicus brief. In fact, the league may have been with us in this brief. I really should have double checked that before coming on here today. Was a case called O'Halloran. And O'Halloran concerned some guidance that had been put out by the Secretary of State surrounding the rights and obligations of election challengers in Michigan. As many of us will remember and are very aware, there was some really abusive conduct by election challengers. People who are appointed by parties or nonprofits in the 2020 election, including most famously the people banging on the walls at the TCF Center demanding to stop the count. Largely in response to what happened in the 2020 election, the Secretary of State put out some guidance that we thought put forward some pretty common sense and justified rules to clarify what the rights of challengers were, and also just gave some guidance to clerks to how to manage unruly challengers, provided some common sense things like, the clerk can appoint a liaison and all challenges have to be directed to that liaison rather than bothering every election worker. So the secretary put out this guidance, and a lower court in Michigan, this came up under Michigan law because Michigan elections are generally governed by Michigan law, not by federal law. And a Michigan court said, sorry, Secretary of State, you can't put out guidance like this. You've gone beyond the law, and you can't do this. We thought that was wrong. The Secretary of State has a fair amount of discretion in what she can do. So there were. I'm not going to get into all of the nitty gritty. There were a number of sub issues. But this issue went up to the Michigan Supreme Court, and shortly before the election, the Michigan Supreme Court came out with a decision that mostly affirmed the Secretary of State's guidance. It held that most of what she had done was common sense rules to govern the conduct in elections. And when we talked at the very outset of this about how smoothly the elections went, this was one really important piece of the elections going smoothly, was this guidance being in place to ensure that challengers weren't behaving abusively and improperly, and that poll workers had the tools they needed to get rid of challengers if they weren't behaving properly. There was one issue the Secretary of State lost on, which pertained to whether or not challenges, even if they're bogus challenges, have to be written down. And the court said, yeah, they do have to be written down, even though the Secretary of State had said otherwise. But that's another, because the conduct of our elections is mostly a matter of state law, it's just another thing that makes the Michigan Supreme Court so important, is they are at the end of the day going to decide most issues about elections in Michigan. There are federal issues, but a whole lot of those issues get decided by the Michigan Supreme Court. And it gives me a lot of comfort, and it gave me a lot of comfort going into this election to know that we had a Michigan Supreme Court that I believe is broadly supportive of an understanding of voting rights and Michigan's election code. I'll talk about one last area where the Michigan Supreme Court has been deciding some interesting cases. And this is also an area actually where they're deciding the cases under federal law, not under the Michigan Constitution specifically, although there'll be a little tweak to that. And this is the area of searches and seizures. We at the ACLU of Michigan litigated a really interesting case a couple of years ago called Johnson versus Vanderkoy. And Johnson versus Vanderkoy was about fingerprint readers. So we all know about kind of fingerprinting in the old school way with ink on your fingers, and you had a piece of paper when you're arrested. But as we've all seen in the movies, there are now like fingerprint readers that are sort of digital devices that can do a fingerprint scan on you, sort of in real time. And these devices can be mobile. The Grand Rapids Police Department had purchased a bunch of these mobile fingerprint readers, and they had instituted a policy by which whenever they stopped someone, not with enough cause to arrest them, which is called probable cause, not with that much cause, but whenever they just wanted to stop someone to ask them some questions about a crime, which they're allowed to do, to ask a couple simple questions if they have what's called reasonable suspicion, which is a much lower level of suspicion than probable cause. And it turned out that Grand Rapids was stopping Black people at highly disproportionate rates for these reasonable suspicion stops and fingerprinting them. And our clients were both children. One of them was the police pulled him over and fingerprinted him. I think he was like 13 years old or something like that. accused him of stealing a fire truck that was really just a toy that he was handing to another child. Another one of our clients was a child who had been fingerprinted while walking through a parking lot, and the police accused him of looking in a suspicious way in cars as he was walking through the parking lot, and they fingerprinted him. And we argued this is unconstitutional. This is an unconstitutional search and seizure. And the Grand Rapids Police Department said, no, it's not, because fingerprinting is not a search. We haven't searched you when we fingerprint you. And that issue, believe it or not, has never been resolved by the United States Supreme Court. So the United States Supreme Court has never said under the Fourth Amendment whether or not fingerprinting alone constitutes a search that would trigger the requirement that you have a warrant or another justified reason with probable cause to do it. So we litigated this case all the way to the Michigan Supreme Court. And the Michigan Supreme Court said for the first time, and this is now the law in Michigan, yeah, that's a search. They're grabbing you, they're physically touching your hands to this device. It's not something we expect as, our normal level of privacy, and that's a search. So that is now the law in Michigan, that it is a search protected by the Fourth Amendment to the United States Constitution. You need a warrant, or there has to be an arrest in order to conduct a fingerprinting. So that was a really big case. And it's one of those cases that could have been reviewed by the Supreme Court, but was not. But a really interesting development in Fourth Amendment law. And then a case to look out for this term, and this one's really interesting because it's at the intersection of federal law, Fourth Amendment, and also of Michigan law, because it's also about the voters' legalization of marijuana under Michigan law. So prior to the voters' decision to legalize recreational marijuana in Michigan, it was well-established law in Michigan that the smell of marijuana gave the police enough suspicion to search somebody. Now that's quite famously been in a power that was often abused. Whether or not an officer really smelled marijuana is obviously something subjective, and it's hard to prove after the fact. They can say they did it, whether or not they did it. So there are undoubtedly, in my mind, a number of searches that happened on that basis that were not properly justified, but hard to fight against. But in any event, at least at the time, it was illegal to possess marijuana. So evidence of its consumption in the form of its smell was, arguably a reason for a search. But now, of course, it's no longer illegal under Michigan law to possess small amounts of marijuana. And so Armstrong arose in Detroit. And Mr. Armstrong was sitting in the passenger seat of a parked car on a street in Detroit. And Detroit police officers drove past the car and claimed to have smelled the smell of marijuana wafting out of the windows. They came and they sought to search Mr. Armstrong, even though he was a passenger in the car. And they said, we smell marijuana. And it's still illegal, for those who don't know, although it's a civil offense, to smoke marijuana in public. And the officer said, that's enough. Smells like marijuana to us, and we can search you. So this issue has now gone up to the Michigan Supreme Court, whether now in 2025, the smell of marijuana is enough for officers to search. And we've made this is another case where we've submitted an amicus brief. We don't represent Mr. Armstrong directly. We've made a few arguments, and they're similar to arguments that Mr. Armstrong has made. One is that, look, the smell of marijuana, anybody who's ever been to a rock concert knows that can cling to your clothes, your body, whether or not you have been actively smoking and whether or not you have just smoked. So the fact that the officers smelled marijuana coming from the car, and by the way, they searched the car and didn't find any marijuana. They found a gun, which is how this case is now coming up, but they didn't find any marijuana. Whether or not you actually smelled marijuana, you're saying you did. It's now as consistent with legal conduct that you were around marijuana while it was smoked at a legal time as illegal conduct that you're smoking it now in public, unless you're seeing smoke billowing out the windows or something like that. And so, that's not a basis to engage in a warrantless search of somebody. That's one point we've made. Another point we've made is, in general, the right to search somebody when you're stopping them and investigating them for an active crime. We're saying smoking marijuana in public is a civil offense. It's something you can get a ticket and a fine for. It's not a criminal offense in Michigan anymore. And the right that officers have to engage in searches, low suspicion searches, that can't apply to civil offenses, So we've made both of these arguments. My wonderful colleague had some time at oral argument in front of the Michigan Supreme Court back in October, where he had a chance to urge our arguments, and we're waiting on a ruling in this case. This is going to be a hugely impactful case. The ease with which searches can be conducted by officers saying that they smell marijuana is just massive, both because they actually did and as a pretext to search people for other reasons. And if we get a strong decision from the Michigan Supreme Court saying not in Michigan, not in light of the legalization of recreational marijuana in Michigan, this is going to be a decision that really is extremely protective and important to protect the rights of people against unlawful searches and seizures here in Michigan. So there's many other cases I could talk about, but I think we're coming up towards the end. I want to leave the chance for any last questions or discussion that anybody would like to have.
Any questions? We can we can let you have their microphone, but you already have your microphone.
I had just a quick question, maybe clarification on the O'Halloran case. You said that the Michigan Supreme Court mostly supported the Secretary of State. Was there some element of that they did not?
Yeah, there was one element where the Secretary of State lost. The Secretary of State had, so she had delineated in her guidance permissible challenges and impermissible challenges. And what that meant is the types of challenges that it's lawful to make as a challenger and the types of challenges that it's unlawful to make as a challenger. Now, there is a statute that says when you make a challenge, when a challenger makes a challenge, the poll workers have to record that challenge in the logbook. So that there's a record of the challenges that were made. And the Secretary of State had said, you don't have to record impermissible challenges because they're not proper challenges. And the Michigan Supreme Court disagreed on that point. They said, nope, impermissible challenges, even if they're impermissible, are still challenges. And they need to be recorded in the logbook so that there's a record of what happened at a later date.
Thank you. Looks like Carrie Willoft has a question. Any immigration rights cases you are working on?
Yeah, thank you, Carrie. I'd love to talk about immigration, which is, of course, an issue very much on our mind here at the ACLU of Michigan. You didn't hear me talking too much about immigration tonight, and it's largely because immigration is an area of mostly exclusive federal control. And so most immigration cases come up in federal court and get decided by federal courts rather than state courts. There are some exceptions. I'll talk about one in a second. We are working on immigrants' rights cases. We have just resolved actually a case we brought at the beginning of the first Trump administration called Hamama. Hamama was a case shortly after the first Trump administration came in, where the administration was rounding up Iraqis who had outstanding orders of removal. But this was, in the context of the Iraq War, and we're going back to Iraq. For many people who may have been ordered removed at a time when Iraq was a safer place to be, it was no longer safe for them to, and they were literally being rounded up and stuck on planes. And we got we literally had an injunction issue while planes were on the tarmac to slow those down. And as a result of that litigation, quite a number of the people in the class that we represented were able to go back into immigration court, reopen their cases, say conditions have changed in Iraq. I'm going to be killed if I'm sent back to Iraq, and we're able to regularize their immigration status and stay lawfully in the United States. That's just an example. We've litigated a number of other cases. We've litigated a case in Grand Rapids about a man called Hilmar Ramos Gomez, who was a United States citizen that ICE rounded up and the Grand Rapids police arrested and held for an unlawful period of time, and then turned over to ICE for deportation, even though he was a veteran, and even though he was telling them that he had a passport. We represented him in that matter. And we're certainly expecting that there are more cases to come. I will say this though about things that could come up in the state, in the state courts. One area that people like most of us at the ACLU here are very worried about is cooperation between state and federal officers, and state and local officers overreaching and doing things that are supposed to be the purview of federal officers. That's an area where if that happens, we may be able to litigate these issues in state court, because it'll be about whether or not the officers are complying with state law. So that's certainly something we're vigilant about and paying a lot of attention to in the current climate around immigration, and something we'll be giving a lot of thought to going forwards. And just in general, I will say, like, there is no issue we are more concerned about as a civil liberties and civil rights organization at this current moment in time than immigrants' rights. It's a really grave risk at this moment.
Lisa has a question. How can we simplify these conversations for those who may find discussions like the redistricting experience overwhelming?
Probably asking the wrong person, as the last hour and a half may have demonstrated. No, but in all seriousness, I will say this. One of the things I love about working at the ACLU is that we engage in what we call integrated advocacy. So we have about 35 staff here at the ACLU of Michigan. Only about 12 or 13 of us, 12 I think, are lawyers. And then there's some other people in our legal department, and about the other half of our staff work in other areas. We have a political department that engages in advocacy in Lansing around things that we can't fix through litigation but can fix through bills. And our political department was extremely active in making Proposition 3, the Michigan overturning of Roe v. Wade here in Michigan. We were deeply involved in that. We have organizers on staff, and unlike me, our organizers are very good at talking about our issues to other folks who may not be interested in a 90-minute technical legal discussion. And we have a communications team composed of former journalists and social media whizzes whose literal job is to take all of this legal gobbledygook that I throw into a 50-page brief and figure out how to write a one-page press release, to practice with me before a press conference about how to not be too wonky, to take that one-page press release and boil it down to a 140-character tweet, so that we can be communicating around these issues. So I would say go to the ACLU webpage, sign up for all of our socials. Like, that's where we try to get things out in ways that are sort of accessible to folks who don't want to have a 90-minute discussion like this. I see Cheryl.
I'm wondering, may I ask a question? I'm sorry, I couldn't find the hand raise thing. What about, has the Supreme Court ever taken on a policy and like the whole transparency that we voted in, we thought, when we voted in the term limits thing, and they have done a terrible job of making us any more transparent. Has the ACLU or the Supreme Court in Michigan taken on a challenge to those kinds of issues, and where the legislature is just not doing a good job? I know there was that case with the wage laws that had been,
that's one of the things I was going to talk about. The other thing I was going to talk about is FOIA. So Michigan we have a state level Freedom of Information Act, just like there's a federal one which allows you to request state records. It's not the best Freedom of Information Act imaginable. And one of the things we really worked hard on last term in Lansing was to try to amend it in several ways. That failed during the lame duck session. But we do have the Freedom of Information Act, and the ACLU litigates under that all of the time. We've recently litigated a couple of cases relating to the Michigan prison facility, MDOC, the Department of Corrections, refusing to turn over body cam footage of like incidents of violence against incarcerated people. And we've won cases holding that, no, you can't like shelter that and say it's like a personnel record or something like that. You have to turn that stuff over in most cases. So that's an example. Another, I meant to say this during the immigration question. We litigated a question up to the Michigan Supreme Court in the past couple of years in which facilities that so we have a few local jails here in Michigan that detain people for ICE and are contracts with ICE. They detain immigrants, not people who are accused of crimes, but people who are going through removal proceedings in immigration court. And we FOIA'd some information from the Calhoun County Jail. And we went up to the Michigan Supreme Court. They were trying to shield that information. The Michigan Supreme Court said, no, you can't shield that information under the Michigan FOIA law. So that's another area of transparency. The case that you referred to, Cheryl, is one that I was going to mention as you were asking the question. No, it's called Mothering Justice. Mothering Justice was about the voter initiative to expand Michigan's minimum wage and sick leave policies. And this gets wonky fast, but the Michigan legislature did a really, like, there's this weird rule: when you get enough signatures to put a law on the ballot, not a constitutional amendment. If you have a constitutional amendment, it goes on the ballot, but a law on the ballot, the Michigan legislature can react in three ways actually. One is they can put their own law on the ballot as well and say, vote for the law that the voters asked you to, and vote for ours, see which one you like better. Or they can say, great, we're going to put this on the ballot. Voters, go vote on whether or not you want this to be a law. Or they can adopt the law themselves. And if they adopt the law themselves, that makes a big difference, because if the voters enact the law, it requires a supermajority of the legislature to amend the law in the future. They need more than 60% to amend the law in the future. But if they adopt it themselves, they can amend it themselves with a simple majority. So what happened in Mothering Justice, folks will remember this, is we the voters said, yes, we want to change Michigan's wage and benefits laws. And the outgoing lame duck legislature said, well, we don't like that, so we're going to enact that law, and then we're going to turn around the next day, basically, and amend that law back to what we do want. And this case has been bouncing around the courts for literally 6 years. But finally, this past term, the Michigan Supreme Court decided that the adopt and amend strategy cannot be used in the same term. So if the legislature is going to use the adopt strategy, it's going to say, in response to a popular initiative, we're passing the law. That same legislature can't be the one to amend it. A future legislature can, but at least at that point, the people will have had a chance to speak again, and democracy will be functioning. Whereas here, literally, you had a majority that got voted out. They lost their majority. And then they chose to abuse the last few days of that majority to undermine the will of the voters. And the Michigan Supreme Court said, shenanigans. And this is a really interesting and important area. This is all about Michigan Constitution. The U.S. Supreme Court can't do anything about this. When I began the talk, I said things about the structure of government are typically things that are within the purview of the state. You know, the U.S. Constitution has no popular initiative. There's like no way to put a popular initiative on the federal ballot if you wanted to. Michigan, like a number of states, but not like all states, really has a fourth branch of government. There's the judicial, the legislative, the executive, and the people. And the people have a role in our constitutional structure that is unique and different. And as a constitutional litigator, it's a really fun area to litigate separation of powers cases where the people are this kind of like fourth branch of government. And so it's a really fun area. That was not, by the way, our case. We were not the parties. We did have an amicus brief in that case as well.
Charles has a question. Any thoughts on what will happen with the bills that were passed but not presented to the governor?
I don't. I literally learned about that in the past 48 hours, Charles, and haven't had a chance to analyze it. So sorry.
Maybe we're at the end of questions.
Yes,
Doesn't
I'm
look- I don't
sorry.
see
I
any
was
others.
trying to get the link to the February program, which I forgot to queue up. But I have here the link to the archive YouTube channel where we will have this talk posted along with our previous talks. And if you want to see a particular topic, feel free to email me. I'm typing it in frantically, yes. And I'm having trouble getting the, we have a program which is specifically on civil rights cases that in the Michigan Supreme Court. So not just the recent ones. Yes, you have it?
And it's done by isn't it the Michigan Supreme Court Historical Society?
Yes,
A
I believe
totally
it's the
different
president
perspective than
of
Phil's
the
to
Michigan
some
Supreme
degree.
Court. Yes.
Yeah. And it
Yes.
should be like so related to all of this to find out what has been done earlier even, and you know.
Thank you, Ruth, for putting that up.
Sure.
We're second Tuesday almost always. Phil, I hope that we can ask you to come again because this was a very interesting and informative talk.
Yeah.
So we can talk
Absolutely.
about possible topics. Thank you very much.
Thank you.
Thanks.
And thank you everyone who came this evening.
Thank you for having me.
Bye.
So I hope to see people later.
It was great. Really great. Thanks for setting this up, Jennifer, really.
Well, Ruth is the one who identified Phil.
Well, Ruth, thank you. That's right. I forgot.
Yeah.
Well,
Yeah, thank you all.
teamwork here.
Great.
Okay,
No,
well,
it
I
was.
think I'm going to end this now. And
Okay.
we can talk again later.
Okay, great.
Thank you. And thanks everyone who came in.
Yes.